Okay, hello, and welcome to the last intellectual property class of the semester, in which we're going to be talking about the right of publicity. So, the right of publicity is essentially the right for celebrities to have the exclusive right to their name and likeness, specifically in the context of endorsement, right? So, it applies in the context of the commercial use of a celebrity's name and likeness. If you want to learn more about the right of publicity, I highly recommend Professor Jennifer Rothman's website, Rothman's Roadmap to the Right of Publicity, which will tell you everything you could possibly want to know about the right, and also tell you everything you could possibly want to know about the right from state to state. Right? Because the right of publicity is unique in relation to a lot of the other forms of intellectual property we've discussed in this class, insofar as it is a purely state-based right, not a right created by federal law. Okay, so where did it come from? Well, essentially, in the late 19th century, then law professor Louis Brandeis and his friend Samuel Warren wrote what's probably one of the most influential law review articles ever written, The Right to Privacy, which was published in the Harvard Law Review. And in that article, they argued that state law provided the basis for what they referred to as a right to privacy, or a right to be let alone. And in response to that article, states and legislatures started creating statutory rights to privacy, rights that enable people to prevent other people from publicizing private facts about their life. Well, the right to privacy gradually grew into a right to publicity, right? In other words, the right to privacy, the right to prevent other people from talking about you, eventually became the right to publicity, or the exclusive right to essentially make money from the use of your name and likeness in relation to commercial speech. Okay, so how did that happen? It was sort of a long, convoluted path, and we'll trace it as best as we can through the cases that I asked you to read for today's class. But the key thing to remember is that the right of publicity differs from state to state. In other words, basically all the states recognize a right of publicity in one form or another, although they're they differ widely in relation to what they recognize and the contours of the right in question. But they do it in really different ways. Some of it do it by statute, some of it do it by common law, and there's different durations for the different rights depending on which state you're in. Some of them have a right that survives the death of the celebrity, some of them don't, et cetera, et cetera. And we've talked about some of this to some extent earlier in the class in relation, for example, to the Jimi Hendrix estate, and so on. But here we're going to dig a little bit deeper into how the right of publicity actually works in practice. So the case provides an early right of publicity case, the Edison v. Edison polyform manufacturing case. Of course, Thomas Edison was an incredibly important celebrity in late 19th, early 20th century America, sort of like the turn of the century version of Steve Jobs or Sergey Brin or something like that, the founders of Google, right? So really important and significant celebrity inventor figure, and among other things, known for generating massive numbers of different inventions, right? He was sort of like the original apotheosis of the American inventor. And among other things, he invented a patent cure for facial neuralgia, of which he was a sufferer. And apparently he sold that cure to the Menlo Park Manufacturing, or what became the Menlo Park Manufacturing Company, or Ediform Polyform Manufacturing. It took many different forms at different points in time. Essentially, it's a consortium of people who figured that they were going to make some bank by selling Edison's patent medicine. They formed to produce it and then moved around and produced in different places, initially not being very successful, but ultimately hitting the jackpot and making a lot of money selling this medicine. But among other things, they included in the advertisement, on the label for their medicine, a certification purporting to be by Thomas Edison himself, saying that, this is the Thomas Edison formula, and they used Thomas Edison's name and likeness on the label to their drug. And Edison objected, in part because he didn't want to be associated with them, and in part because they weren't actually using his formula, right? They left out the most important, the secret sauce. They left out the morphine. So it wasn't even his formula in the first place. And ultimately, after considerable litigation, the New Jersey court, which was where Menlo Park, where Edison was based, was located, ultimately held that the defendants were not permitted to use Edison's name and likeness and his purported endorsement, which wasn't real, on their labeling because he had not agreed to it, and because, in addition, they weren't actually using his formula, so it wasn't truthful. Okay. So fast forward to the 1940s, and we have a situation where a college football player gives to his athletic director the right to use his name and likeness in promotion of the football team, and Pabst Brewing, wants to use his image as well. They're really excited about using his image to sell lots of beer. Turns out he doesn't believe in drinking beer, and he's very upset about this. And he had previously rejected offers to have his name and likeness used commercially, and objected to Pabst Brewing's use of his name and likeness as well, and brought an infringement action saying, or rather brought an action saying they shouldn't be able to use my name and likeness to advertise beer because I didn't agree to it, and in fact I object to beer drinking. It's against my Christian beliefs. He was at a Texas Christian university. And ultimately the court said, well, actually you gave the right to, promote the football team using your likeness to the athletic director. You can't now come in and say that they can't use it. They paid the person who you gave the right to in order to use it. And what's more, being associated with beer doesn't make you look bad. There's nothing wrong with beer. Beer is totally fine. You can't object to having your name and likeness used in this advertisement, even though you personally object to beer, because there's nothing intrinsically wrong with beer. Well, okay, so this is very early days as the right of publicity is emerging as a concept, and actually this may be familiar. Honus Wagner, the most expensive baseball card in history. Why is it so expensive? Well, baseball cards at the time were actually cigarette cards. They were included in cigarette packs, and Honus Wagner was a popular baseball player for Pittsburgh, and famously objected to smoking, or at least arguably objected to smoke. It's a little clear how much he actually objected. In any case, the practice at the time was for cigarette companies to have agents to go around and talk to different baseball players in order to get their permission to use their name and likeness in cigarette cards. Somebody apparently was playing a little fast and loose, didn't get Honus Wagner's permission, and ultimately he objected. So what did the cigarette company do? They pulled all the Honus Wagner cards, right? They stopped selling them. As a consequence, those were incredibly rare cards because Honus Wagner stopped them from being sold in the same volume as other cards were being sold at the time. As a consequence, the rarity of this early cigarette card made it incredibly valuable, because the only ones that were out there were the ones that had been released by the company before they pulled that particular card from production. Why does that matter? Well, the most important case in right of publicity, kind of founding case for right of publicity, involves baseball cards as well. Also involves cigarette cards, or rather, these were a little bit later, so they were sold with various kinds of candy, not with cigarettes. But Halen Laboratories v. Topps Chewing Gum. Okay, so what happened here? Halen Labs at the time was the dominant player in the baseball card business, and they went out to all the different teams and signed the players into exclusive contracts. In other words, they got the players to sign a contract saying, you can use my name and likeness on your baseball cards, and I won't make a similar contract with anyone else. Okay. Well, Topps wanted to enter the baseball card business as well, but you can't go in the baseball card business unless you can sell cards with the names and likenesses of baseball players on them. After all, that's the whole point of baseball cards. So they went out to all those players and said, hey, don't worry about those Halen people. We'll go ahead and make a contract with you as well. We'll also sign a contract with you to include your name and likeness on our cards. And don't worry about the exclusivity thing. It doesn't really matter. Okay, well, Halen's not thrilled. It brings an action against Topps, essentially saying that Topps had more or less infringed on its contractual relationships with the baseball players. The fundamental question here was, could the baseball players sell the exclusive right to use their name and likenesses? Topps's argument is no, right? We're just getting essentially a promise on their part not to sue us. Halen says, by contrast, or sort of the way it kind of cashed out at the end of the day, was that this was actually like a property right. Right? That when the baseball players engaged in an exclusive contract with them relating to their name and likeness, that they were in effect selling the right to use their name and likeness to Halen, and therefore Halen could enforce that right against third parties, and the Second Circuit agreed. It said, yes, the right of publicity is a property right. It can be alienated by the celebrity, and in this case, Halen has purchased it by forming an exclusive contract. Therefore, Topps is infringing, and they're liable to Halen under the circumstances. Okay, so fast forward to the 1980s, and an enterprising individual running the American Heritage Productions company decides that he's going to make some money by selling busts of the civil rights icon Martin Luther King. So he manufactures these busts and puts ads into Ebony magazine, offering them for sale for $30, and some of the money will go toward charity. Essentially, he sets aside about $1 per $30 bust to go to charity. Otherwise, he's just selling these busts for making a profit. And essentially the Martin Luther King Jr. estate objects, saying, hey, we don't want you doing this, and we have a right of publicity in Martin Luther King's name and likeness that prevents you from selling this material. And ultimately the Georgia court agrees with them. It says, look, the right of publicity provides an exclusive right to use the name and likeness of a celebrity in a commercial way. In this case, they're selling these statuettes, they're selling these busts, that's a commercial use, and therefore they're liable. In addition, right, it also says that the right of publicity survives the death of the celebrity, because otherwise it would just be too uncertain, et cetera, et cetera. You don't want to tie the right of publicity to the life of the individual, because in a sense, the value of the right of publicity not only can, but does survive the life of the person in question. In fact, in many cases, becomes even more valuable after a person has died. Notably, there's a pretty robust dissent to the opinion, not necessarily objecting to the outcome, but objecting to the terms, right? Saying, hey, we should be thinking more carefully about the First Amendment questions implicated by the right of publicity under the circumstances. After all, what do we mean by commercial, right? Is any kind of sale commercial? I don't think so. Right? There are lots of kinds of semi-commercial transactions that also have a strong expressive component. Here, it might be more commercial than expressive, but we can certainly imagine circumstances where the use is primarily expressive, and we wouldn't want the right of publicity to prevent the use of a celebrity's name and likeness, especially a celebrity whose name and likeness are so bound up in really important political values like Martin Luther King. Okay, Carson v. Here's Johnny Portable Toilets. So you may or may not be familiar with Johnny Carson and his famous tagline. Here, let's play the tagline here with Ed McMahon.
From Hollywood, the Tonight Show, starring Johnny Carson. This is Ed McMahon with God's Services, and the NBC officer invited to join Johnny and his guests, Charles Nelson, Bo Derek, Pete Condon, all making it different, and from the San Diego, you're different. And now, ladies and gentlemen, here's Johnny.
Okay, so Johnny Carson, the host, a longtime host of The Tonight Show, with his famous tagline, "Here's Johnny," So here's Johnny Portable Toilets starts selling porta-johns under the name Here's Johnny. And Johnny Carson Enterprises brings a right of publicity action against them, arguing that they are improperly using Johnny Carson's name and or likeness and or celebrity aura, as it were, in order to sell products. The response is, hey, Johnny is just a name, right? We're not saying Johnny Carson. We're just saying, here's Johnny. And y'all call, what's a porta potty called? It's called a John. Right, so this should be fine. Why is that infringing? The court, however, recognizes that the phrase "Here's Johnny" has come to be associated specifically with Johnny Carson. Right. In other words, why are they using the phrase "Here's Johnny"? Because they're trying to make a reference to Johnny Carson, and they're capitalizing on Johnny Carson's fame in an effort to sell porta potties or to rent porta potties, notably with the phrase "world's foremost commodian." Funny pun there, as it were. And you maybe start to see some of the overlap between the right of publicity and trademark law, right? A lot of similarity between the two, although right of publicity can stretch more broadly than trademark law can, right? Is anyone confused by the relationship between the porta potty company and Johnny Carson? Presumably not, right? People know that Johnny Carson probably isn't in the portable toilet business. However, they make the association, right? So maybe it's kind of like a dilution action here, but it doesn't require the same level of celebrity, or at least it doesn't require, or at least arguably doesn't require the same level of fame as we would expect for a famous mark in a dilution context. And it's also enforceable by comedians or by celebrities in different contexts. Okay, and here's another one wonders whether this version of Here's Johnny. Here's Johnny. Ought to cause us to think differently about how the right of publicity ought to work, especially in respect to phrases like this. After all, it's clearly conveying lots of expressive content. When the portable toilet company uses the phrase "Here's Johnny," are they only trying to draw on Johnny Carson's fame, or are they also engaging in humorous expressive speech that ought to be protected by the First Amendment? Who knows? Well, in any case, Midler v. Ford Motor Company case is really interesting because it involves Bette Midler, the famous singer, and her refusal to participate in a Ford commercial, right? So basically, Ford wanted to make commercials for the Mercury Sable, was trying to appeal to a yuppie type audience, and they went to Bette Midler to see if she would let them use her popular song, "Do You Want to Dance?" And she said, "No, I don't do commercials," right? They're like, "Oh, what do? We really want this song." She doesn't own the song, right? Somebody else wrote the song. She just performed it and recorded it on her album. So why don't we go out and find a Bette Midler sound-alike? We'll have the sound-alike do the song for us. And here you go. Here is the commercial.
Now there's a car that just asks to be driven. Mercury is bringing a sophisticated new shape to the American road. Introducing Sing. Mercury, the shape you want to be in.
Okay, so I'm kind of reminded of Matthew McConaughey selling Buicks, right? I mean, Mercury Sable, whatever. So they went ahead and had a sound-alike perform the same song. The song doesn't belong to Bette Midler, but it's very strongly associated with her. And the entire purpose of the advertisement was to kind of evoke Bette Midler. Midler brings a right of publicity action, and the court ultimately says that a person's singing voice is very distinctive. Therefore, by trying to copy Bette Midler and effectively succeeding, the Ford Motor Company has improperly associated Bette Midler with their automobile commercial and thereby infringed on her right of publicity. You might ask whether this actually makes sense. After all, it's not her song, right? There's no copyright infringement involved because they licensed the song from the copyright owner and paid the person who performed it in order to use the recording that they created. It's not her fault. She sounds a lot like Bette Midler, or at the very least, she's entitled to sound as much like Bette Midler as she wants to, is it appropriate that Bette Midler could bring a right of publicity action under the circumstances, even if it is in fact the case that audiences might associate the commercial with her? After all, they never say Bette Midler. They're just playing the song. It happens to be associated with her. Is that a problem? Should it be a problem? Should we be worried about it? You might also ask how close the resemblance actually is. Here's an actual Bette Midler recording. So anyway, insofar as the song was super popular, they actually don't sound that similar, I don't think. So one wonders whether viewers would actually be confused about the association, but nevertheless, Bette Midler did prevail in this particular action. Okay, and we'll proceed to another really interesting case. So White v. Samsung. Vanna White, best known as the co-host or hostess of the very popular long-running television game show Wheel of Fortune, was parodied by Samsung Electronics in an advertising campaign that it ran looking to a bunch of different celebrities with perceived kind of evanescent fame and saying that, well, Samsung products are going to be around forever. As it happens, Vanna White is still more or less in the business, so I think she may have retired recently. In any case, they made an advertisement using Vanna White, or rather using a robot styled to resemble Vanna White, saying longest running game show 2012 AD. It's actually quite a bit in the past now. And the VCR you'll be taping it with, 2012 AD. I don't know when the last time any of you used a VCR was, if ever, but predicting a future for the technology that did not ultimately transpire. Regardless, Vanna White brought an action arguing that the image in question violated her right of publicity by evoking her likeness without her having agreed to or profiting from the use. And the response, of course, was, look, it's a robot, right? It's a robot in a blonde wig. We're not using your name. We're not using your likeness. It's just a robot. The court ultimately found in her favor, saying that the context conveyed to consumers that this was supposed to be Vanna White, and when used in a commercial context, that was sufficient to violate the right of publicity. There were some really interesting, strong dissents, both by Judge Alarcon on the panel and also from several other judges in the en-banc rehearing of the case, arguing that this is really a First Amendment problem and that the right of publicity shouldn't be extending this far, right? It's kind of pushing for a sort of form of fair use when it comes to the right of publicity, and people have continued pushing for that, right? So one of the big concerns in relation to the right of publicity is the extent to which it potentially infringes on First Amendment interests, and many people have argued that there should or needs to be or must, by virtue of the First Amendment, be a kind of fair use equivalent to the right of publicity, exempting expressive uses from the scope of right of publicity protection. But we haven't quite gotten there, at least not on the federal level. And I guess we'll see whether or not the Supreme Court ultimately takes it up and finds something along those lines.